Evening and welcome to the February 6, 2023 meeting of the Lake Oswego Development Review Commission. Kat, would you please call the roll of commissioners present?
Arthur.
Here.
Smith.
Here.
Shear.
Here.
Poinsett.
Here.
Sangre.
Here.
Lyons.
Here.
Hughes.
Here. Excellent. We have a full complement of commissioners and a quorum. The meeting will now come to order. Our first item of business is to review and approve the minutes of the January 4th, 2023 meeting of the DRC. These have been circulated in advance to commissioners. We've had an opportunity to look at them. Commissioners, are there any changes to the draft minutes, or is there a motion to approve as submitted?
Move to approve.
Second.
All right. All in favor, say aye.
Aye.
Aye. Any opposed? Any abstaining?
Abstain.
Very good. The minutes of the January 4th, 2023 meeting of the DRC are approved as submitted. Our next item of business relates to LU 22-0052. As you may recall, this is a request for a conditional use and development review permit. Actually, Commissioner Scherer, we do not have minutes of the January 18th meeting.
Okay.
And we're going to skip over those, but we'll look forward to seeing those at the next meeting. Okay. And with relation to LU 22-0052, these are requests for permits for a new transportation depot, sometimes colloquially called the bus barn. This is a minor variance to increase the maximum fence wall height from 8 feet to 10 feet, and it also includes the removal of 3 trees. This site is located at 6333 Lakeview Boulevard. Staff Coordinator, Senior Planner Fran Stead. City Attorney Boone, are there matters we need to take up before proceeding to this item?
Yes, Mr. Chair, there are 2 procedural requests by...
Would you guide us, please?
Certainly. The Rosewood Neighborhood Association has submitted to the Commission 2 requests to reopen the hearing. I'd go through those. The first request to reopen was on the allegation that there was new evidence that was submitted during the continuation portion of that hearing. As the Commission may recall, you had a hearing on January 4. It was continued to January 18. Oral and written testimony would be permitted to be submitted at that hearing. There was no limitation that it be done to new evidence, rebuttal evidence, et cetera. It was kind of an all-comers presentation that any person could submit. The hearing was held. Then after the Commission closed the hearing and proceeded to deliberation, we received a request to reopen by the Rosewood Neighborhood Association on the assertion that there was new evidence contained in submission by the school district that they would like to have an opportunity to rebut. Of course, the Commission has already gone through the tentative decision process, the deliberation process, and so you have received in your packet exhibits H001, 2, and 3. Let me see if that's all of them, and 6, which relate to that request. It's, as pointed out by, well, it's staff's position that the requestor, Rosewood Neighborhood Association, waived the opportunity at the time of the close of the public hearing, before the testimony was closed on the 18th. They did not request an opportunity to submit additional rebuttal information to the Commission, which would have been permitted under the code, but you have to make that request before the close of the public hearing. The Commission is aware in their written material that their response is, well, we didn't have a change to, one, it was difficult to review all of the submission by the applicant because it was submitted on the 17th. Our staff's position is that since any new evidence could have been presented even on the 18th. So that's not extraordinary for new evidence to be submitted on the 17th. The written materials had to be submitted by noon of the day of the meeting, and it was submitted by the school district 24 hours before that. Then secondly, If they hadn't gotten through with all of review of the evidence, they certainly had the opportunity to ask for the opportunity to continue the hearing to review and submit rebuttal information if there was any new evidence. Kind of like at the end of most of our initial evidentiary hearings, we ask for the opportunity if somebody wants to leave the record open, somebody asks to leave the record open, and then they decide whether they want to submit any material or not. You know, sometimes when they have the record left open, they don't submit anything new and go there. So they could have done a precautionary new evidence. So our position is that the staff's position is that they waived the opportunity to do so. I think they then argue, well, we didn't know that we had the opportunity to do so, and there's no requirement, I mean, it's in the code, and there's no requirement that I read, like the first one, what the procedure will be. So we would support the applicants, or the school district's applicant's argument on the waiver. Okay. You have all the written material.
Excuse me. So City Attorney Boone, I understand this first request, on the one hand, is to reopen the hearing, or on the other hand, to strike the so-called new evidence?
Correct. I don't think, on the striking, it was properly submitted. So I think.
I was just
That might be
referring.
my short argument on that one. I don't think we could strike it because it was properly submitted.
Very good. So we need to decide that as the first item of business.
Okay.
I'm proposing that we decide it on the written materials. Is there a commissioner who would like to hear an oral argument from any of the parties? If that's the will of the commission, we can do that, but I'm proposing that we decide the issue on the written materials unless there's a different consensus on the commission.
I thought the issue was whether or not we're going to reopen.
In order to decide it, I'm now asking, do we want to hear oral argument from the Rosewood Neighborhood Association and the applicant, or are we going to decide the first issue on the written materials? I'm proposing we decide it on the written materials unless there's a strong feeling that we want to hear oral argument from the two parties.
If I may, Mr. Chair.
Proposing that we just look at the written materials to determine whether or not we should reopen?
Right.
Okay. These written materials.
Right. In other words,
versus written materials and allowing them to testify.
provide oral argument in support of the written materials. That's right.
Okay.
Are you in favor of oral argument?
No. I support your position. I just didn't quite understand.
Oh, I'm probably not being clear.
Okay. So, Attorney Boone, did you have a comment or?
Well, I just wanted, on the process of that, I just wanted to be clear that what we told both parties was, when we received the request, I said, well, I would give two days to the school district to provide, I provided my response, my initial response back to Rosewood on my analysis of it. And I said, well, we would give the school district an opportunity to submit by Wednesday, last Wednesday, and then you would have an opportunity to submit by Friday, 4 p.m. That's when they did so. And we did not indicate that there would be any subsequent process before the commission, that we expected you to receive it on written materials.
I just wanted to be sensitive to that point. So we need to decide at this point whether to reopen the hearing to receive additional evidence. Am I correct?
Well, I think you have a request before you, a motion to strike and a motion to reopen. So I guess you could decide, you could take, you could move to deny the request to move to strike at this point. Okay.
I had understood from your advice that that was mostly a moot issue, the motion to strike, and we're now dealing with whether to open the hearing.
Well, I would go ahead and, I mean, I think it's, I don't think there's the grounds to it, obviously, because there's no grounds to strike material that was properly submitted. That, to me, is a very short argument on that one. Then the second motion would be on the motion to reopen based upon to not reopen on their motion based upon the waiver argument.
Okay, well, you did circulate these materials in advance. We've had an opportunity to review them carefully. Commissioners, on the general issue and motion to strike, how do commissioners feel? Are there any thoughts on this one way or the other? Or is there a motion? I had questions. I'm looking at the January 25th, 2023 email from Ms. Jenny Davies. She comments that it was unusual for the DRC to, quote, excuse, close quote, the applicant from having to make its rebuttal on the evening of the January 4th hearing. I wasn't actually attuned to that. Is that an unusual or an improper move for the commission to allow the rebuttal to be given at a continued part of the hearing?
I would say no. The commission's practice has been if you're going to have a continuation of a public hearing, which you're going to receive oral and written evidence again, some more, then why go through a rebuttal on today when you could do a rebuttal 2 weeks from then, and everybody has the opportunity to submit written argument in rebuttal of what was submitted that night. So I don't think that's unusual at all, and certainly no prejudice to any parties.
And when we continued the hearing for both oral and written testimony, didn't that include the opportunity for anyone to submit new evidence, not just limited to the applicant's rebuttal evidence?
Oh, yeah, absolutely. That's what we said. It's open for new evidence, rebuttal evidence. It's all comers.
So as I understand it, the Rosewood Neighborhood Association received the new evidence at some time, perhaps on Sunday, or the day before the January 18th hearing. I'm looking now at the January 26, 2023. I'm sorry, I must be mistaken here. I thought there was a statement by the Rosewood Neighborhood Association that they had access to the applicant's so-called rebuttal materials and new evidence on the city website at a certain date, and that didn't give them time to prepare for the meeting. Was the applicant's rebuttal and new evidence submitted late?
No. No, the written material needed to be submitted by the 18th at noon, because that's when any written material needs to be submitted, and they could have submitted any oral, which could have also included new evidence, at that meeting.
And you spoke earlier of a waiver, and I see there's some discussion in the materials about a waiver, what's a waiver, a knowing and intentional waiver. But isn't this basically a failure to preserve the right to attack the new evidence that was properly admitted?
Yes, I mean, the opportunity to request a continuation for written rebuttal to any new evidence that was submitted before the 18th was not requested. Therefore, that time has passed. That's our position, city's recommendation.
Commissioners, are there other questions or comments on this first issue? Is there a motion to strike the new evidence or to decline the motion to strike?
I would move to decline the motion to strike because I do not see grounds upon which to grant that motion because the evidence appears to have been properly submitted according to procedural rules.
Second.
Any further discussion? I do have one question. City Attorney, excuse me. However we vote on this, is this something that one or either party can appeal to the City Council?
Oh, yes.
Okay. This specific item on the motion to strike. Okay. Let's go ahead and call the roll, please. And what is the motion?
May I have a question?
Yes.
Along the same line, there were comments in the package of material that opening and having a discussion at this meeting might preclude some elements of appeal to City Council, that there might be an advantage to having a discussion of
I think
these.
that's on the next, the second grounds for reopening.
Right.
So I'm only focusing on.
You want to
this
focus on this one only. Thank you.
Yeah, one at a time for me, yes.
And what is your motion? I'm sorry.
I would move to deny what has been characterized as a motion to strike the additional evidence submitted.
Thank you for that clarification. It's been seconded. Let's call the roll.
Arthur,
Yes.
Yes.
Shear,
Yes.
Poinsett,
Yes.
Sangre,
Yes,
Lyons,
Yes.
Hughes.
Yes.
Chair, the second motion for to consider would be a motion to decline to reopen the hearing on the, due to the failure to request that reopening timely.
Very good. I did read with interest, and I do sympathize with lay neighborhood association board members who work full-time. You know, we as commissioners are volunteers. I certainly have an occupation that takes up my time, and I'm happy to volunteer, but I understand that it's hard sometimes to juggle things. So I am sympathetic with that. Is there any motion or further discussion on the request to reopen the hearing? Do you have a question or a motion?
I was wondering if you do.
No, I don't.
Okay. So I move to deny the request to reopen the hearing.
Is there a second? Second. Any further discussion? Call the roll, please.
Arthur,
Yes.
Smith,
Yes.
Shear,
Yes.
Poinsett, Sangre,
yes,
Lyons,
Yes.
Hughes.
Yes. City Attorney Boone, is there a further issue we need to take on?
Yes, there is the second request to reopen the public hearing, and that has to do with new evidence that was reportedly received by the Rosewood Neighborhood Association after the close of the public hearing. I refer you to Exhibit H005, my memorandum addressing that. The request to reopen is in the commission's discretion prior to adoption of final findings on it. I have recommended that that any exercise of discretion would be based upon the same circumstances that the council would be considering if this matter were before the council, and that is whether or not there is an unanticipated event that occurred after the close of the time to submit evidence. If the commission adopts that process as I've laid out, I think what they've alleged is that the county traffic engineer, they think is supporting their original argument on the site distance, the applicability of the site distance and how that's measured. They've made the argument at the hearing on what they thought the site distance was, and now they think the traffic engineer is supporting that. My analysis is that that's not an unanticipated event that has occurred. That's just additional expert testimony that they want to submit in response to that. So I would recommend, as laid out, that the commission adopt that standard for review and then decline to reopen the hearing. If the commission doesn't adopt that standard, I would still recommend that you exercise your discretion not to reopen the hearing, just in a general way, because what that does is you're going to encourage, I'm going to find another expert, and you're going to get more requests to reopen. They had an opportunity to get their own experts. They don't have to rely on the county. They can get their own traffic expert. So that was kind of a consequence of their selection of who their experts were. So.
Vice Chair Smith?
So is the request based on information that they found after the hearing was closed?
No, I guess the answer to that I think is no. It is information, well, it's an opinion that was received from the county traffic engineer of what the site distance, how that is measured. And I want to be clear in saying that they think that that supports their position.
My question is, when did this information from the county engineer come into existence?
That was on January 24. and your hearing, you closed it on 18th.
So the record was closed, we had deliberations, then the association found additional information after the hearing was closed. And based on information that they located after the hearing was closed, they want the hearing now to be reopened.
Correct.
Okay. So I move that we deny the request to have the hearing reopened.
Is there a second?
Evan, I have just a question. I didn't hear what your first suggestion was, what you suggested the action be.
Oh,
I didn't quite
well,
hear what you said.
You have the discretion to reopen the hearing, and it doesn't, the code doesn't say what the parameters of that discussion are. You have two bases of exercising your discretion. One, it could be whether or not there's an unanticipated event, okay? And you say, well, there's not, someone would. Or, no, I'm not gonna do it because it's just additional evidence and confirmation of a testimony we've already received, and we're not gonna receive additional evidence from experts confirming on, so you're not gonna exercise your discretion. Now, the motion was to just not reopen without stating the basis of that, so that's fine.
No, I need to
Oh,
reform my question.
I'm sorry.
You suggested we deny the motion and do what with the information? Is that a better question?
Well, you're just going to, let's see, you're just going to deny that. I don't think you're going to do anything with the information because you would just.
I thought you said you put it in the record for the city council or something. No.
Well, the basis, I mean, if the commission wanted to hear evidence on it as to whether or not that evidence supports their position, you could reopen it and take that evidence and then redeliberate on it.
I understood your memo and stuff. I just thought you said something more when you explained it. That's why
Okay,
I misheard you.
Staff's not recommending, I'm not recommending that you reopen the hearing to
I got
take
it.
it
I
and
knew
close
that,
it back
but
up.
I thought you said,
I believe you may be, Commissioner Scher may be referring to your comments about the city council using the, unanticipated event as a basis for considering whether to admit new evidence.
Right. Yeah, I mean, they'd have to determine that in their own light. My recommendation to the council would be the same one I make to you. I don't think that's an unanticipated event. I think that's trying to find more witnesses.
I think the second basis on which you said we might consider denying the motion makes sense to me in that the way I read the request is that the neighborhood association argued that the applicant utilized improper sight lines or sight distances, and that they received additional evidence after the record was closed that supported that argument, but we had already heard and considered that argument during our deliberations, so I would probably deny it based on that fact.
Okay, there's a motion pending. It has not been seconded. Commissioner Sanders?
Attorney Boone, would you clarify for me whether this motion could be supported by a comment that was based on an interpretation and analysis of the data submitted in the appeal or in the request specifically? And I think it's very much the same question that Tim was asking. We could deny on the procedural basis, which is the first of two elements that you offered, or we could deny by saying our interpretation of the new information that has been provided is that it is in no way contradictory to the evidence that was introduced and the discussion during the hearings. That would be a second justification for us. Is that a legitimate justification, and how specific would we have to be about that?
Well, I think that is a legitimate basis to make your decision. If you're going to, I think I would want, so the council knows that you've considered the veracity, if you will, the credibility of the evidence, then I would add that in the motion, you know, as Commissioner Lyons has indicated, that doesn't add any new information to what wasn't already received in the record and it was considered by the commission.
Fine. In that case, I would like to rescind my second and offer an expansion on the motion. Deny, that is your motion, but I would add, based on an assessment of all of the new information that has been provided and the conclusion that there is no evidence that that is in any way contradictory to information that was presented during the open hearings.
Does the mover agree to that? Because we're a little parliamentary. I think, okay.
His motion, and I'll second.
All right, we have agreement on the motion. Is there further discussion?
I'll just say that I'm in agreement on that. Having studied the information, yeah, I didn't see anything that came to a conclusion. In fact, well, I'm in agreement with that, so, yeah.
Do we need to specify a certain standard we're deciding the motion on, or is the general motion?
No, well, I think the motion states the standard in that there has to be, you know, some worthiness to reopen the hearing. And if it all agreed with, it was consistent with prior evidence, you've heard it all before, there's nothing there to reopen.
Very good. Let's call the roll on the motion, please.
Arthur?
Yes.
Smith?
Yes.
Shear?
Yes.
Poinsett?
Yes.
Sangre?
Yes,
Lyons?
Yes.
Hughes?
Yes.
The motion passes. Thank you very much. And I appreciate the efforts of the applicant and the Rosewood Neighborhood Association. We'll now move ahead, as appropriate, to a determination of the draft findings, conclusions, and order on LU 22-0052-2043. These have been submitted in advance to us. Commissioners have had an opportunity to review the draft. I just wanted to confirm with Vice Chair Smith that the conditions, particularly B9 and perhaps C2, is it? The conditions
B9C2.
are consistent with the motion you had made earlier.
They are.
Very good. Are there suggested revisions to the draft findings, conclusions, and order on LU 22-0052? Or is there a motion to approve the findings, conclusions, and order preliminarily as submitted?
Move to approve.
Second.
Any further discussion? Hearing none, let's call the roll, please.
Arthur?
Yes.
Smith?
Yes.
Shear?
Yes.
Poinsett?
Yes.
Sangre?
yes.
Lyons?
Yes.
Hughes?
Yes.
Very good. The preliminary findings, conclusions, and order are approved. Will they come back to us a second time?
Your question, Mr. Chair? These
The
are not
motion to
coming.
approve these is passed.
Right, they're adopted as passed, and it'll now start the appeal process.
If any.
I'm sorry, the reason I was inquiring, Mr. Lyons, how did you just vote?
To approve the findings.
Okay. You voted
No.
negative.
Correct, affirmative.
So unless you've changed your mind.
I have not changed my mind.
Okay, so this should be recorded then as a no on the adoption.
Okay,
of the
my
findings.
apologies. I understood it as approving as it was reflected with
Yeah.
my no vote, but understood.
Okay.
Thank you for that clarification. Pardon? Anything further on LU 22-0052 for this evening's meeting?
Not that I'm aware of.
If not, we'll proceed to our work session. And I really appreciate Commissioners' willingness to participate in a brief work session for our DRC. As we completed the year last year and looking forward into this year, there were just a few operational items that I thought I could benefit from as a commissioner, having kind of a regrouping on and a review of. And I asked commissioners to submit points of discussion for our work session. And with the support of staff, we now have a schedule of topics we might suggest discussing tonight. So with that, I'll turn it over to Director Namanaloo and City Attorney Boone.
Thank you, Mr. Chair. Everyone should have received a sheet, and this is just a summary of the topics that I received from the chair, along with maybe some additional questions or follow-up as it was presented to staff. And we've just kind of put it in what I thought was a logical order, and I thought we would just go through them one by one, and certainly feel free to ask questions as we go along. And I think we'll just get started if you're ready. And the first item was about site visits. And this came up because I know that there is some confusion by commissioners as to whether or not they should be making a site visit. And,
Yes.
And if the commission does want to make site visits, should perhaps you look at having a policy or a standard for making these site visits? Perhaps should you consider that they be organized and monitored by interested parties, or perhaps the commission could consider just purely looking at the application based on the testimony and the evidence that's in the record.
Right.
wanna
I mean, I think some of our commentators or citizens who attend the meeting have the expectation we should be out viewing the site. And based on my prior experience on the Planning Commission, I came away with the impression that one should avoid doing site visits. If we're a quasi-judiciary body and we're listening to evidence, I wouldn't expect a judge to go out and talk to people outside of the hearing of the parties or do his or her own investigation. So I always had the bias that we shouldn't be doing site visits, but maybe we should be in some circumstances. And if so, what is a site visit? Because I might just drive by the location. Another commissioner might get out and walk the property or look at adjacent properties and do a very thorough investigation. So what is the standard and that type of thing? So I appreciate the opportunity to discuss this.
Yes, this issue reoccurs. And as the attorney, I start with the back end. You're to make a decision based upon the standards and criteria as to what the evidence in the record shows. The evidence in the record consists of written and oral testimony that has been presented to you. Well, when David Powell started this, he said, well, we recommend no site visits because you're introducing the potential of considering evidence that is not in the record. We call it quasi-judicial because it's not quite judicial. It's kind of half and half. But I think generally, what we've come to in the city attorney's office is saying, well, we recognize that you're members of the community, that you have knowledge of what things, where sites are, you drive by them, you can't help but see them. The trick in the quasi-judicial hearing is to declare at the first part, when we ask for ex parte declarations, including a site visit, that's when you would declare anything that you saw that was material and the circumstances in which you saw it, okay? Because that evidence, if that evidence was important to you in considering the case, then all parties need to know what you think you saw. Because what you think you saw may, in fact, not be what the facts are. The example I've always used is if the issue was traffic, which sometimes comes up in this body, what you saw at 9 o'clock on a Sunday evening has really no relevance to traffic at 9 o'clock on a Sunday morning, or on a Monday morning. So if you say, I saw the traffic, that doesn't tell the parties what the circumstances were. If traffic is a material consideration, you'd want to say, well, I went there at 9 o'clock and this is what I observed. I observed 30 seconds of backup at the traffic light, or something like that. Because if you're saying that that's the material element, material evidence that you're considering as to whether or not the criteria is met, that needs to be in the record so the parties have an opportunity to contest it. It makes it difficult, too, of course, for parties to contest what the judge has seen. That's kind of puts the parties at a little bit of a disadvantage. They have to show you why you were wrong and what you think you saw. But, yeah, if you went out there, be as specific as possible. Clearly, the context is important on many of these criteria. So, a generalized awareness of what the area is helpful. But it should be, and it should be supported by evidence that's in the record. The parties should not be, and you don't want to encourage the parties to rely on you to provide the contextual information to make the decision as to whether or not it's complementary to other buildings of good design. Because if they don't put it in the record, and if it's just in your mind, then if it gets appealed, it goes to the city council. It's not in the record. Okay? If it gets appealed to LUBA, I can tell you it's in nobody's mind at LUBA as to what's, there is no evidence then to support it. So sometimes, while people who ask you to take a site visit may think if you don't, you're kind of not doing your duty, actually you're making, if you don't do a site visit, you're definitely making them do their duty, and it preserves the record for their arguments on appeal on up the way, everything. So, because the evidence is limited to what's in the record. So now we did have, there is, by one anecdotal use of a commissioner, the issue was about the health of a tree, and we found out that the commissioner went out on the site, observed the tree, did a core sampling of the tree, declared that at the deliberation side, not the best way to do things. You gotta, if you're, you just want to kind of get if you're going to do a site visit, it's just a broad brush thing, and tell us what the circumstances were when you went out there to do the site visit, if that's material. It might be material. And by declaring that you went out there, then the parties can say, well, when did you go out there? When did you see, type of thing. They can kind of hone in on that, but at least declare that you've had a site visit. If you saw something that was definitely important in your mind as to addressing the criteria, state that so the parties can inquire further, pro and con, sort of thing. So I guess it's not prohibited. It's sort of helpful to give some context if you have time to do it, but it's also the party's obligation to establish in the record what the evidence is on each of the criteria, and so they should be prepared to do so, and you should expect them to do so, not relying upon your site visit. Don't feel bad about saying, I haven't been out there, because it's their obligation to bring you in the evidence. And they can do that. We're sophisticated here. They can do it by photographs, video, drones. I mean, they can provide you all the evidence they need.
Commissioner Scherer, did you have a question or comment?
Well, I was just thinking, I like being able to make site visits when I need them. And I was just sitting here thinking, I've lived here since '68. I've lived in 6 different places. And so I'm fairly familiar with the area. But there has been times when I'm reviewing record that I can't for whatever reason, get the site or whatever we're considering into my mind, and a site visit for me then makes all the difference in the world. I mean, I can just drive by and look at it. So I would hate to see us do away with that. I would not want to go by a site visit with interested parties.
Oh, yeah,
I would not do that.
right. And let me just say, we have done that, the commission has done that in a very rare occasion. I think it's happened at least once, maybe twice, where at the hearing, basically, both parties sort of asked for, because it was it had to do with a view that you could see from somebody's deck kind of a thing.
Yeah.
And so it was a proctored site visit. I mean, it was scheduled up, and we had the two parties come out there. We had the recording secretary out there, tell them, don't talk to anybody. They're out there just to put their eyeballs at this particular spot, and then come back in. So it would have to be coordinated in that case, but very rare.
So I kind of like the rules the way they are. I don't always make site visits, because sometimes I already have whatever we're considering in my mind's eye, so I feel like I don't need to. But I would hate to see us not being able to do that. Wouldn't want to do it with the parties, and so as long as you declare it, I think we're fine, and that's how I feel about it.
Any other questions or comments on site visits?
Well, I'm sorry.
Go ahead. Okay.
Sorry. From my perspective, I characterize myself as a dirt lawyer, right? And so if I can, I kick the dirt on every project, because I'm really good at looking documents and CC&Rs and title reports and surveys, but I kick the dirt because, I mean, if I can, or I think it's warranted, I go out there and see what's going on. And I think since I've been on the commission, the city's had site visits to show us, bigger projects. I didn't know that there was a policy that the city attorney didn't want us to go there because what we saw wouldn't be part of the record. So, my bad, but, and so I like Jeff said, I think it's fine. And I do site visits when I think that they're warranted. And if I don't think they're warranted, I don't go. And, as an attorney, I've got a thick skin. So when, they call me out for not doing a site visit, okay, so.
Thank you for that. Commissioner Sangre?
Yeah, I was just going to agree with the general principle. I think the process we have is working. I think disclosure is critical, disclosure among ourselves as to what we might have seen and what we have concluded, if anything. The one additional comment I would make is I personally feel that as a rare occasion, the commission may decide that we want to do a site visit, in which case I'm sure we could develop appropriate and consistent with the law procedures for us. But I think that only if the commission wants to do it should we do an acknowledged formal site visit with all of us participating.
I appreciate that comment. I think that's very useful.
Eric, may I respond?
Yes,
Kind of
of
open
course.
discussion here, kind of thing. The obligation of the commission is to decide the case based upon the record presented to it, okay? Not necessarily to go out and gather evidence.
Right.
So that was a very, as I say, one case, maybe two, in which that's happened, a very rare case, because it's really, the question is, has the applicant met the burden of presenting the evidence that shows that the criteria is met based upon all the evidence that you consider? So why would a commission, and that's, when does this arise? When the commission says, well, I vote we need to go out and see it. Well,
Evan, that was why I really was trying to make 2 points. Number one is only the commission can decide we're going to do this. We're not going to be responsive to anybody else who says, you guys ought to do it. Well, we'll hear that, but it's our decision. The second is we do that in concert with you, who tells us what's appropriate in terms of what we do and what we,
process.
how we report that. And I don't know what all that is, but I believe that you would make sure I did the right thing.
Right.
So those are my 2 points. I think they're separate. But this is a very, very rare occasion. And as you said, maybe your example of everybody really needs to go up on the deck and decide whether they do or do not see Mount Hood or whatever.
Yeah, it was basically, in that case, I think, stipulated by the parties to present in that evidence, which it doesn't rarely. That's pretty rare. The parties are going to stipulate what the evidence should be.
Yeah.
Sorry, I was just going to say, I don't know if we need a hard and fast rule that we don't conduct site visits, but I would say in general, it would be preferable in this sort of context to not make site visits. My experience, limited though it may be with civil litigation, is that site visits were conducted by parties and their attorneys, not by the judicial body. And it seems that in reviewing these applications, as you said, City Attorney Boone, that the burden is on the applicant to present evidence, and it is on us to consider evidence in the record. And I think that the more we stick to that general framework, the better we'll be, and the more easily a reviewing body could review our decision on appeal.
Yeah, but I'll say at the same time, reviewing that evidence, just oral and written, sometimes there's photographs or renderings, and those two-dimensional don't necessarily help me to really understand what the issue is. And so just to be able to make a physical view of, in my mind, of what the area looks like, or that it helps me quite a bit, actually. And I don't mean a technical visit, but just an understanding of the project site. Yeah.
I think I agree with that. The essence of what you're saying. It's just, if I were to make a site visit, maybe I make my site visit at 9 in the morning and you make yours at 2 p.m. Or maybe I make mine on a particularly busy traffic day and yours is on a slow day. And also, even during the disclosures, how do I ensure that I'm accurately conveying all of the information that I gathered at the site visit, so everybody knows the basis upon which I'm voting?
Yeah, I guess when I do a site visit, I'm not looking at traffic or anything technical per se. It's just for my own sense, my visual sense of the project.
Yeah.
I don't know if that's a material condition or not, but.
I guess I go back to the burden. I mean, the burden is on the applicant to demonstrate that they've met the criteria. So if they can't adequately demonstrate that through the means available to them.
Yeah.
But again, I don't know if I'm not advocating or moving for a hard and fast rule that site visits be prohibited. I'm just saying my general thought on it is that we should take consideration of some of these. We should do them sparingly, in my opinion.
So I guess maybe we got kind of, there's been a lot of talk on traffic counts based on whether or not it's a Sunday morning, or I don't think when I go to site, I don't do that.
No.
When the city proposed the driving range and the golf course, and there was trees tagged that were going to be removed, and part of the project was in one application and another part of the project was in another application, I had to go out there and look and try to figure out what was going on. And so I even asked a question, what about those 2 trees by the old, oh, that's in the other application. Well, little circles with little leaves on a tree map that, I'm sorry, that doesn't do much for me. So, but I understand, I thought there was a lot of traffic. Okay, well, what day was it? And I get all that. But I don't do site visits for that. I try to get the lay of the land and give me context to what, like you were saying, the 2-dimensional surveys and tree things with little leaves are, so.
Well, it sounds, excuse me, it sounds like the more restrictive view that I held as a planning commissioner should be more relaxed for the DRC, and that we, from time to time, as each commissioner deems appropriate, can make site visits and declare that, but give a detailed, somewhat detailed description of what we did and what we saw, perhaps when we went out there, and that should suffice.
So Randy, is that, I know that you've mentioned it before, I guess, was it a concern that you, as a planning commissioner, you weren't supposed to do site visits, or is that?
Well, that was my understanding, and perhaps it was under the view and the opinion of a prior city attorney that site visits should be very restricted, and if you go out, you give a detailed description of what you did or saw for issues that would come up before the planning commission, for example.
I think our position, at least at this point, is to provide context, a broad context of the site. Okay, that's living in Lake Oswego, you're going to get that. That you're appointed from Lake Oswego. You can't get that out of your mind. And it may provide you some assistance in looking at the detailed information, the photo that comes in. Well, where was this photo? It helps me see where this photo was taken. But I need that photo in order to meet the criteria. So as long as you aren't relying upon what you saw, that you're relying upon the evidence in the record, fine. And of course, disclosure is the name of the game up front.
Well, Evan, I do have a question about, with today's technology and Google Maps, you can fly a site and put the address in and go down and put the little man in there and look around and see. If we do that, do we have to declare that as a site visit?
Yes.
Okay.
Okay, because that is information that you've gathered outside of this hearing body. So anything you gather and any kind of, yes, if you go home to your computer, okay, that's a site visit. That's ex parte contact, because that's not information in the record. So just like a site visit, you need to declare that. And then it's a little more difficult. Okay, I flew the Google man over this thing, and this is what I saw. Okay, what was the date of the photo that you were flying? Because Google has different dates, so it's have to disclose that. So it's.
Yeah, and I don't think we would want to recommend that you do that. And we did have a commissioner in the past who, we were talking about design, and one of the issues was the particular architectural style. And during deliberations, he said, well, I Googled this and I looked up, and then it was like, oh no. And he didn't declare that, yes. And it's fine, and I understand the wanting to do that, but what Evan is, I guess, basically saying is nobody knows what's in your head. And so if you're doing your own research, then nobody knows what you're basing your decision on. So I think if you're going to make a site visit, if you declare it, I think it's been working fine. We haven't gotten any complaints or had any major issues with it. So I think keeping the existing practice is fine, but just declaring what it is that you saw and not trying to gather your own evidence. And I would say, stay off Google Earth, if you can. We tend to try to give you aerial photographs and other information, but if you can, I think that's probably best.
Thank you. Well, I think that's good guidance on site visits. Anything else anyone wants to state about site visits? So our next issue is a refresher on the scope of DRC review and application of the criteria. Something near and dear to the city attorney's heart.
All right. Well, the commission, as you know, is required to make a decision based upon the criteria and standards. So, I think these two questions kind of go to what extent should you receive information, encourage information from the audience, interested parties, that are not related to criteria standards? Well, I guess I would first say that if a party is testifying and they're presenting something that we're saying like, well, how does this relate to criteria standards? We should be asking how it relates. Because if they think it relates to criteria standards, we need to understand that. What was not cited as criteria in the staff report that they think is applicable, we need to know about, because we need to respond to that in the findings. Okay? If they're working on some different theory than staff is working on, we need to know that. The commissioners need to know that, because if in fact you find that basis, as a criteria or standard, then you can apply it. So if somebody is kind of coming in not on a well-trodden path from the criteria standards identified in the staff report, certainly ask how that relates to criteria standards. If they can't say it relates to any criteria standards, they just want to tell you stuff, okay? They have 5 minutes. They can use their 5 minutes to talk about relevant stuff or irrelevant stuff. So I think that it's helpful for them to know that it's irrelevant. I think that sometimes I'll ask a witness as to what criteria standards relates to. The commission could as well. If they need to know whether they're just kind of wasting their time, type thing. On the issue about how does the commission respond to irrelevant material, once you've decided it doesn't relate to criteria standards, but they're testifying about irrelevant stuff and you're going to respond to that irrelevant material, well, one question, staff's sitting there, well, does that commissioner think it's relevant or not? How do we respond to that in the findings? Okay, type thing. And I think by encouraging, I think that my personal theory is, I think by encouraging discussion about items which are not part of the criteria standards, you're inviting more testimony about information that's not relevant to criteria standards, because the parties are thinking you're going to take that and weigh that in your overall opinion as to yes or no, kind of thing. So, that's why I kind of grimace when commissioners start asking follow-up questions about matters which we haven't established as relevant, as to both of you. How do you see it as relevant? And if you don't see it as relevant and you need to apply the criteria standards that are relevant, where are we going with this? While people have the right to testify for 5 minutes on anything irrelevant that they may wish to do so, I guess I would suggest the commissioners refrain from following up and spending time talking about irrelevant material, because I think it tends to solicit additional irrelevant material, and it creates confusion for staff as to what we're supposed to do with that in the findings.
Can't, in some circumstances, such testimony or questions following up on it provide context for the application, or provide some discussion for the public to provide context in a helpful way?
Well, are you saying that by discussing it, we're going to kind of lead them to some relevant criteria? Is that what you're?
Well, I think so, to illuminate a little more broadly than just the criteria, what the context of the application and what's going on, what the applicant is trying to accomplish.
Well, the commission.
Maybe not, I'm just asking.
When you say the applicant is trying to come, and I know we've had prior cases in which, we kind of, sometimes commissioners, well-meaning, try to decide whether this is a good project or not. Gee, you could design it better, or you've got, what about that? That has nothing to do with land use and that sort of thing, nothing to do with relevant criteria, but it could be a better project if this, or the neighborhood's worried about that, but it's not relevant.
Or like surface water runoff, or
Well, surface water runoff is usually relevant.
Yeah.
To the criteria.
But you're not, are you using this approach or that approach? And basically, that's something I think that has worked out with the city engineer at time of permitting. Isn't the standard whether they can come up with a proposal that will meet the standard, whether or not they're proposing a specific A, B, or C? Not to digress on that.
It's an art, not a science. I mean, if you're going to take testimony that you think might wander towards a relevant criterion and how they would accomplish the criteria, okay, but, we're going to be kind of raising our, I raise my eyebrows and say, where are we going with this? And you can say, well, I'm trying to figure out how, whether or not this meets the stormwater criteria. Well, that's helpful to know which we're going. If we're just following up on, I hope I don't pick any current commissioner, but somebody asked a question once about a school, and, well, how are the lockers designed inside the building? I mean, where does that go, type of thing. And to me, that does, then the district says, well, we're gonna have lunch at 12:30. I mean, you get into operational stuff, which isn't, they're trying to sell the program not on the standards and criteria, but on the others, on the non-relevant stuff. And you shouldn't be making a decision. I hope, the public shouldn't perceive that you're making a decision, yes or no, based upon the way the lockers were designed. I mean, here's the shiny object over here, and if you like that, you should approve this project, even though the project may not meet the criteria, but I'm going to show you that this is a great thing. Okay?
And I think we have two examples that are pretty clear from this most recent hearing, namely whether or not the school district was intending to electrify its bus fleet, not relevant, and whether or not the school district could have or could acquire property in another city. Very much probably relevant in the community's mind, or at least in the neighborhood association's mind, as to whether or not this is a good project, but neither go to the criteria that we were reviewing.
Excellent examples, and I think those are issues that I think we brought up. So take those to the board, the school board. We are not the school board. We don't manage the resources. We don't decide which property they just go investigate, that sort of thing. The question is, does this property fit this criteria, type thing? And by listening to that discussion without kind of shutting it down early, you're going to get more of that testimony about it. So, yeah, the electrifying buses issue, of course, the case is still active. We dealt with that in the staff report by saying that we didn't identify as a criteria. I mean, the criteria did have to do with fumes and smoke and that sort of thing. So, but they weren't saying that they were using electrifying buses. We weren't using that to meet the criteria. So the question is, did the current ones meet it? And then what the staff said was, if they change, because this always comes up in a modification of a conditional use, if they change their operation, does that require a modification? So we anticipated and said, well, if they go to electric buses, that shouldn't have any fumes, so that wouldn't require a modification, because relative to the criteria, that's not a modification. It's within the scope of the approval type of thing. It's less impacts, not more. If they did it in reverse, that would be an issue. But excellent examples.
Yes, I think Commissioner Lyons raised an excellent example, but in that case, I think, in my view, it was worthwhile to inquire, well, is this an electric vehicle facility, and what weight should be given to that testimony? It seemed like somebody had mounted a campaign in the community to support the application on the basis it was an electric bus facility, and I didn't feel it was, and I thought it was a good point of clarification there for the broader context.
Well, the staff report said, as indicated in the narrative, they're running the buses they have today. There was no promise. This was not a conditional upon changing their fleet. So the discussion in the community about what the school district, what they'd like to have, is not the application you had before you.
Right, and I felt that was important to make in the public presentation to that point, not everyone's reading the staff report, and if we had just all read it silently and
And I think
acted on it.
it's fine for people who want to testify about that subject to say, look, that is not this application, go talk to the district if that's what you want to do to try to encourage them to acquire more electrified buses, type of thing. But that's not the role of this commission, yeah.
No, I agree, and sometimes I have to think, well, this is really a bad idea as a policy matter, I wouldn't want this, but that's not one of the criteria or criterions.
Right.
Are there other thoughts on how, commissioners, how we can focus on the criteria in our deliberations and our questions, or in drawing out, clarifying the testimony?
I mean, it doesn't seem, we don't have a means of limiting their testimony. Nobody can object and say irrelevant. So maybe we can, would it be helpful to just kind of not ask the follow-on questions if they're not necessary, but to the extent we even entertain the argument or the conversation, just saying like, this is not something we were considering, and whether or not we were approving this application, just making it abundantly clear.
Well, I think and just free form here, I think if a commissioner doesn't know what criteria and standards they're addressing, ask. Because in their mind, if they are, you need to know that. And that's an individual commissioner thing, I think. But feel free to ask.
I've certainly been guilty of some of the things that you've mentioned, and it's.
But not of what I actually mentioned. So.
No, and I just want to say, this is helpful to, as to what's criteria and what's not, and how there's still going to be a gray line there, and I think I'm going to be relying on City Attorney Boone to help me along the way as we're going through these.
I try not to, I really do. I try not to interrupt them as they're testifying. If they're just going on and on and on about a subject, what's the criteria you're asking about? So feel free to, I think the commissioners should feel freer than I to ask somebody while they're testifying about a subject, how does this relate to criteria standards? Because otherwise, I kind of put it up under their 5 minutes, they get to say whatever they want to. Then your questions kind of signal to me whether we're off, whether you're receiving that as irrelevant, or whether you think that is relevant. And then I'll ask you the follow-up question, well, what relevance is it, type thing. So.
No, I do have ingrained in the back of my mind the City Attorney Boone saying, apply the criteria. So I may be asking a question that isn't related directly to criteria, but I generally am following that guideline. Then this next issue is one that I find perplexing when testifying or commenting, a citizen or expert or someone asks a question, what is the standard, or what is this fact, or wasn't that shown? Because it kind of, if I'm leading the meeting, it kind of throws me for a loop, because I'm thinking, well, I'm not supposed to be testifying, but I don't want to be rude, but sometimes I may come across as being abrupt and saying, we're not here to answer your questions. How should we address that?
Well, yeah, they have their 5 minutes. They have their 5 minutes to ask or to make their testimony. Their time stops when they're responding to a question from the commission. If they're asking a question of the commission, their time doesn't stop. Okay? The time for 5 minutes is to make their case, their position known. You can ask follow-up questions to clarify that sort of thing, but they can't. They're not cross-examining the commission. If they wanted, they have an opportunity to talk to staff ahead of the time, before the meeting. The staff report comes out 10 days before the meeting, so there's 10 days, probably 8 business days. Talk to the commission, talk to the staff rather, about the standards and criteria. So. They don't have to wait until their time for 5 minutes to tell you whether the criteria or standards are met, to ask what the criteria standards are. Okay, they should be, so I think they should have been asking those questions ahead of time. You don't, you're not the you're not the professional staff to respond to the questions. You're to weigh the evidence relative to the criteria and reach a decision. So I think the answer is the commission is not, the commission is to hear your testimony, and whatever you think is appropriate that we hear, this is your 5 minutes. I think. But we're not here to respond. Individual commissioners are not expected to be professional staff.
And if they have questions, they can direct it to staff outside of the hearing.
Right. Right.
Okay. Because I just feel like it's rude to say, well, we're not going to answer your question. Because we're not here to respond to you. But that is positive and constructive. We're here to listen to your comments and testimony and weigh it with everything else. And if you have questions of staff, you can ask them after the hearing.
Right.
One of my suggestions, which we can easily do fairly quickly, is, and I can't believe we've never done it before, is to have a guideline for testifying at DRC meetings that we can post online, we can distribute when someone signs up to testify, and we can put at the back of the on the back table for people who come in personally. And as part of that, we could answer questions like this, like, can I ask commissioners questions and why that might not be appropriate, or about ex parte contacts, or even about whether or not the DRC makes a site visit. So we can draft that up, and if you want, the chair and vice chair can take a look at it, and that could be a resource that you could point to people to when they ask that question. You can say, well, you can give them a short answer and say, there's more information on the, there's a handout in the back that discusses why we don't answer questions.
I think that would be constructive, and it would set reasonable expectations or help in that regard.
We will draft that up, and I'll get if you'd like, you're welcome to review it before we finalize it.
Sure, and then commission can approve it. Thank you. Then we had.
So, Randy, before we go on, Evan, you mentioned that it's their 5 minutes and they can read the phone book, theoretically, if they wanted to. So when we had the drone after drone after drone after video, we just have to sit there and watch this stuff that obviously these people didn't. Because I'm expecting testimony from the person, but if they're just a shill for somebody else to have them, is that really testimony from this person, just to say, hey, this person handed me this video, this is my testimony? I mean.
The video is already in the record. I mean, it has to be submitted by noon the day of the record. So, so nobody really has to, present the video as part of their public hearing. They are presenting it within the context of their testimony to highlight some aspect of the video, or to aid in their testimony. Your point is, no, sometimes people have nothing to say except they want to show me a video that somebody else made. There's nothing in the code. We can't shorten a particular person's testimony. If they want to present irrelevant stuff, so be it. If they want to present information that's read from somebody else's phone book, okay, read from somebody else's material, so be it. You can, as a commissioner, you can indicate your displeasure of that. That's fine, because you can say, I don't give that much credibility because you weren't there to observe it and that sort of thing. So I don't, in my mind, it doesn't kind of go to the weight of the evidence, but they get their 5 minutes.
So are we supposed to basically, we're trained to authenticate whether or not, and maybe that's what kind of grated me, is like, this person doesn't know whether or not it reflects what they're saying it is, because somebody handed them a video and said, hey, watch this drone movie. But so you're saying after the person says, hi, I was handed this video, and that's my testimony for you to play it, then are we supposed to follow up and say, did you take these videos, and how did you establish this is your testimony? Or they can say, this is my testimony, I want you to watch this video. I guess I'm a little confused.
Well, I mean, this is not a court of law. The authentication process for evidence is not applying, I think. They're going to, You can certainly, I mean, they're going to say, I want you to watch this. You can ask questions about how it came to be. But I think ultimately if they said, I don't know, I found it on the street, but I want you to see this. I don't think there's a way for us to say, no, we are not going to hear your testimony, okay, before you've, received it all. You can say it's irrelevant. I mean, that's, but that's, there's, so far in the 20 years, we've never struck anybody's testimony before they presented it because they didn't have a basis to do so. Well, we've had people who came in to testify who lived in Portland who wanted to come in and testify about trees in Lake Oswego. Okay, how you make yourself, if you're an aggrieved party, okay, in your mind.
I mean, if they love trees and that's their opinion and it's their testimony, then they can take 5 minutes to explain to me how much they love trees. I don't have an issue with that, but for them to say, we want you, Commissioner, to watch 2 hours of drones and little yellow buses and not being, I mean, okay, but I guess if they said, hey, I made this video and then let me show you why the buses, can't get through, or the city engineer should make a report, great, tell me about it, as opposed to, hi, my name's Kirk, watch this video. Okay, thank you. I mean, so are you saying when they do that, it's my job to say, I wonder how relevant what that person did by saying, hi, I'm Kirk, watch this video.
Well, the chair has the discretion of trying to discourage repetitive testimony. So if you're looking at video after video of the same thing, I think you can ask, well, what new am I seeing here? But
not to exclude it.
But, well, and I don't know how you...
It was your fault.
If they can't give you the context of why you should be watching it, you can say, well, we'd rather not see it. It's already in the record. But if they want their 5 minutes, I think they get their 5 minutes. That's the bottom line I get to.
And it's up to us.
We've had some crazy testimony, okay? And we've sat here for 5 minutes.
Well, what if there's testimony that is just blatantly incorrect
Well,
or wrong? If somebody says Fifth Street is one way and it's causing traffic problems, and that's not the, do we just listen to their testimony and not say anything? Can we challenge that or question them about that? Or how do you respond to something that you may know is just not correct?
well, yeah, you would challenge them on that because now you've got evidence in your mind from your observation that you're using to counter evidence that you're receiving. So I think you'd want to disclose the evidence that you have in your mind because that's ex parte, okay?
Okay.
And so you're challenging and say, well, my understanding of the facts are different, okay? I've been down on Fifth Street.
So that's appropriate.
Yeah, I think so. You didn't know you had ex parte information because it really wasn't presented. I mean, it wasn't, when the staff report came out, it didn't say Fifth Street ran, only one way. So when you know that Fifth Street runs both ways, but if you get somebody who comes in and testifies that your Fifth Street only runs one way, and you think that's not the case, yeah, I would definitely challenge that because if they need to have the chance to show you you're wrong. Okay? Okay. Now, it's also the job of the other interested parties to rebut evidence. So they should be also rebutting that statement. Okay? So you don't have to leap up every time, but it's ultimately the applicant's burden to show that the criteria is met, and if somebody's making a false statement, usually in opposition, but could be in then it's the applicant's job to lay that out in the rebuttal side. That's the incorrect information.
And for us to weigh the credibility or the weight.
That goes to the credibility if you find that in fact that testimony was incorrect, it kind of goes not only the testimony If credibility is not only about that item, but anything else they might have said, that's up to you to consider in trying to determine whether there's substantial evidence in the record to support the decision.
And then we had a point about voting protocol.
Yeah.
And that came up tonight, actually, with Commissioner Lyons and voting on the findings, conclusions, and order on the bus barn. So perhaps you could clarify that a little bit.
Okay, well, let me start with that. So the findings are the actual decision of the commission. And so your vote should be consistent with your tentative decision unless you've changed your mind, okay, which, sometimes happens. And if that does, it's helpful to say, nope, I've changed my mind, just so we don't think you kind of missed it. So those are the findings of the majority, you're not saying as an opposition or in a minority position, yes, that is what the majority thought. I don't know how as a minority you can say what the majority thought, the majority will speak for itself. So you should vote no if you don't agree with those findings. The minutes, any other questions on that?
I guess just since I'm the one who got that wrong, just to make sure I understand. So when we review the minutes, it's more of a confirmation that, like, yes, I agree that is what occurred and it's accurately reflected in these minutes.
Right.
But with the fine now, and just in reading the document, so what I'm used to, just to give some context, is an order from the Public Utilities Commission of Oregon, where they would have something that says, these are our findings on which we're making our decision, and then, 4 of us say yes, 1 of us says no, we take 1 vote on it. Whereas here, it seems, based on what you're saying, what we're doing is we're restating our vote, which I don't really understand what the purpose of that is. Why would someone change their mind in between? It doesn't really seem appropriate to me.
Well, okay, let me use that example. I've never gone before the Utility Commission, but like any board, they'll take evidence and argument, then they'll go back, in their offices, they'll draft up and they'll come out with their decision. And you may get a 4-to-1 vote for saying this decision opinion I agree with, okay? The one saying I don't agree with it. Now, maybe they're going to write a dissenting opinion, maybe they're not. You don't know why that person, if they didn't write a dissenting opinion, disagreed. All you know is they didn't agree. In this process, we don't go back to our little offices before we decide how we're going to vote. The commission is giving staff a tentative direction to prepare findings. So we kind of need to know which direction we're headed. And then the majority would say, yes, those are the actual, we agree with those findings. So that's why there's a little difference, I think, in why there's a tentative decision and then a final, is you're not producing the final opinion without having a tentative decision, okay?
Okay, so we're saying, let's say we take a vote and 6 of us say yay, 1 says no. Staff goes back and drafts findings based on that, and we're kind of confirming.
Right. Well, the 6 are confirming that's their decision. The no is still a no. We don't know what the reason for that no is, except you would have stated that in the minutes, in your deliberation, you would have stated, I'm voting no because of, you certainly can't do that, I'm voting no because of, and the minutes would reflect that, leading to your point on the minutes. The minutes should be accurately reflecting the positions of each of the commissioners, okay, to the extent they can, so that when it goes, or if it gets appealed to the city council sees the minority position stated in the minutes, okay? So, sometimes the city council has reversed the decision of the DRC, but so that's why it's helpful to state your reason for voting in opposition, because there's no minority report that goes up to the council. That's going to be contained in the minutes.
Right. So could you state then would you say, because findings I think of as the findings on which we're basing a decision. Like, we find that it does not meet criteria A, it does not meet whatever, or it does meet it. But in the document I'm looking at here, which has findings and conclusions, it seems like a draft order. It is hereby ordered by the commission that the city, et cetera. So are we not voting to approve the order, or is it voting to approve, to acknowledge that the findings are accurately reflected in the order?
Well, from a minority position,
I guess I would just ask, like, because I don't know if we always succinctly state this, but when we vote on the findings, a yes vote is saying yes.
we approve the findings and the order. The order might be approval for the application, or it might be denial. I mean,
Okay.
depending on what the commission has tentatively decided. And we would say the order would be let's take a denial. The order would be to deny the application, and the findings would say, we agree with the staff report except X, Y, and Z, okay? Because those three things weren't met. And then, so that would be then approved. You approve the findings, conclusions, and order denying the application for those reasons. That gets appealed at the city council, and they'll decide what they, take a look at those three items, see if they agree with you or not. You know? But I also, when it goes up to city council, all criteria are open, okay, sort of thing. So it doesn't mean, even if you do a denial, it doesn't mean we're just focusing on the three reasons for denial. The applicant still has the burden of showing that all the criteria are met. Too.
Okay, thank you.
A
That's
small item there.
very helpful.
Okay.
Thank you.
On the voting of the minutes, if I may.
Commissioner Scheer had a question.
So you said if I change my mind between our meeting
yeah.
and accepting the findings, I just have to say, yeah, I'm a no vote now, I changed my mind. But how does that work? I mean, with ex parte contacts, you don't know what's happened in the last 2 weeks.
Right, and you would, right,
It kind of sounds like, you know, I think a board's a play. I don't really think you should be able to change your vote.
well, a tentative decision is tentative, and we've had cases in which people have changed their minds, and we've gone, you know, in a 4-3, and then it became a 3-4, you know, and had to go back and draft findings on the other side. Because in reflection, a person says, well, I've reconsidered, I've listened to the deliberations of my fellow commissioners, and, you know, I was originally there, but no, I'm actually persuaded. You know, I think there are times in which a commissioner, after the meeting, has said, you know, I'm rethinking that, I see that point, I didn't see it before. And you would state, you know, I think a commissioner would state the reason why they've changed their mind. It wouldn't just be, I've changed my mind. I mean, I think you would, you know, to the audience, to the people, for public process, you know, I heard that issue, but you know, I was kind of going on this path, but now I perceive, you know, I see the point that really that had nothing to do with the criteria. I don't know how you. I don't know what the facts are. I don't know why, you know, what the analysis was. But there are some cases, very few, in which a commissioner has said, you know, I've rethought it, and I need to change my vote. So, and they explain why they changed their vote, and then that's in the minutes. So.
I mean, that just doesn't, you know, there's a little bit of pressure for us to make our decision tonight. Whatever we're here, and then to be able to go back for 2 weeks.
Well,
I mean, I get it if I could understand it if the findings, we met on Monday and we had the findings on Tuesday, and by Tuesday you thought about it overnight and you changed your vote. I could get that, but not 2 weeks. I don't think that would be right.
Well, right, and I think in that case, I mean, if commissioners is going to change their vote, then it's helpful to talk with staff about that ahead of time to know how that's going to impact our drafting of findings. Sometimes we come up with 2 sets of findings. Again, very, very rare, because if we got the official tentative, but we may have that, and then we've got the 120-day deadline to deal with, and so we would like to avoid having to go another 2 weeks before adoption of different sets of findings, you know, sort of thing. So that's when you would certainly let us know if it's going to be that pivotal case. But, you know, I mean, there could be a case in which a person, you know, let's say it was well, 6-1 or 5-2 or something like that, and the minority person, position said, you know, I've rethought it, and now I kind of agree with majority on that one. Well, you know, that doesn't usually affect the findings, so just state the reason why. But again, it's a tentative decision because we have to go back into our offices and write, okay? And you're not committed until that's the final version, and that's why we remind, good opportunity to remind the commission that ex parte rules still apply, you know, because if you receive new evidence, you know, that is affecting your change in vote, that's a problem, that thing. So we shouldn't be considering ex parte information, I think, so.
And on the question of abstaining from voting in relation to quorum requirements, or?
Well, before you leave the issue of minutes, when commissioners abstain from voting on the minutes, and I think that's probably because you're so used to, on the decision-making, the findings, conclusions, and order, you're only permitted to vote on those if you have in fact reviewed the record, okay? That is a quasi-judicial decision that you're making, okay? The adoption of the minutes is an administrative decision, okay? It's not held to the same level of scrutiny, if you will. It's not held to the same level of analysis required. An administrative decision can be based, somewhat like a legislative decision, based upon the best evidence that you have to decide whether that's correct or not. So you don't, even though you were not at a meeting, you're not necessarily required, it's you know, your call ultimately, but you're not necessarily required to abstain because you were not there if you have talked to you can talk to the other commissioners and say, does that reflect the meeting that was there? Because you have, you've worked with the commissioners long enough, you know that they are good records of the meeting beforehand. If you know and the expertise that the staff puts in preparing the minutes, that it's likely correct, you know, type of thing, that's kind of a preponderance kind of thing. I can approve the minutes based upon that. Ultimately, remember that the written minutes that you're approving, we actually have a videotape. And even at LUBA, we put in the minutes as part of the record, but if a party thinks the minutes are not accurate, they can bring in the videotape, they can bring in this other evidence to contradict that. So it's not, you know, it's not the be-all and end-all if you approve minutes and it turns out that there's some error in the minute, type thing.
So you don't have to have reviewed the tape for a meeting you were absent just to approve the minutes of that meeting?
No, you do not. Okay? Because ultimately the tape will speak for itself if it really gets down into it. Okay?
So on an abstention, how is that counted on whether or not they pass or not?
Okay, well, that's a great lead into that last one, is how does abstaining vote count? Well, first of all, we have to have a quorum, okay? So that's, you know, 4 out of 7. So we can have a meeting, we got 4 out of 7. Then we have to have a majority of those present and eligible to vote, okay? So when we're looking at the quasi-judicial tentative decision or adoption of findings, who's eligible to vote is somebody who is at the meeting, okay? We're looking at the adoption of findings. So the person would abstain because they weren't at the meeting for the adoption of findings. We don't count them in whether or not the majority is met, okay? Because it's only a person who is who's present today and eligible to vote is counted in the majority thing. Minutes, you're eligible to vote whether you were at the prior meeting or not. Okay? So that's an administrative decision, so that an abstention then essentially counts as a no. Okay? But as I say, that doesn't, I mean, usually, everybody else has voted aye, somebody wasn't at the meeting, so it's, you know, it's not a big deal.
So, Evan, what's the point of me approving minutes of a meeting that I wasn't there? But I abstained because I had no clue and I didn't review the tape. So I guess I'm a little confused
Well,
why I would approve minutes that I don't know if they reflect went on.
As I said, ultimately, it's up to the commissioner. It is not illegal, you're not legally invalid to approve minutes that you are not at, if you can do so based upon other evidence, which can be the other commissioners themselves, or the long-running history that you have, that the minutes have been prepared that actually reflect it. You know, it's been 25 out of 25 times, that's been accurate, so now I have number 26 here. Type
No,
thing.
I was more, I guess what I was hearing is that if we didn't have a majority to approve the minutes, then maybe if you weren't there, then you might, so we wouldn't have to come back or
Right.
something.
And I mean, sometimes when you get only takes 4 to have a meeting, but if two of those people who are at this 4 meeting weren't at the prior meeting, then you got a 2 and 2, type thing, so you can't approve the minutes. That would not be an approval of the minutes. Those persons are eligible to vote. So, and sometimes those minutes have been about matters on appeal, sort of thing. So you do want to get the minutes approved. Ultimately, the minutes, need to be approved sooner or later. So if it matters not on appeal, it kind of makes a lot of difference whether it's 1 week or the next week. But that's why it's not a big deal, and I haven't pounded the table if you abstain on it, and if you don't want to vote on it, fine, unless we're down at the 2-2 kind of decision, I think. But technically, that has the effect of a no vote, because you're eligible to vote on approval of minutes.
Okay, but a commissioner who doesn't feel comfortable approving the minutes because he or she wasn't there may abstain. If it's a 2 and 2 vote, I guess we would carry it over to the next meeting.
Yes,
Or
unless
just
there's...
approve it because we trust
Yeah.
our fellow
Right, you could do
commissioners.
that, yeah.
Right.
I voted against because I don't trust them.
Right. Yeah, the commissioner, and that kind of just dawned up. It's totally up to commissioners to decide when to abstain. You can abstain on these minutes. You can abstain after you've sat through 3 hours of hearing. I mean, I can't force any commissioner to vote yes or no, okay? But in that case, it's counted as a no, because you're eligible to vote. So.
Well, fortunately, I think every DRC meeting we've had a quorum, except for one that I can think of, but we typically have a quorum, so that's good. I appreciate the dedication of our commissioners.
Can I follow up on this?
Sure.
This is my question, and it's based on our experience, my experience a year ago, maybe not quite that. Am I correct in saying that if we have a tentative decision that is in a 4-vote majority, that is then passed into the next hearing time, the next meeting, when we vote on the final approval of that finding, right? But we have to have at least 4 votes affirmative in support of some finding at the first date. Do we need 4 votes the second time that are affirmative?
Okay. On the same rule applies, but maybe a little different. When you're at the conclusion of your initial evidentiary hearing,
Right.
You've completed your deliberations, you've sat through the hearings, you're all eligible to vote. Okay? You vote, you need a majority of those present, because they're all eligible to vote, you need a majority of those present to direct staff on how to prepare the findings. Sometimes we've had, let's say we have 5 commissioners. It might be a 3-2.
It would be sufficient in that case. 3 votes affirmative would be sufficient in that case.
Right, 3-2.
Yeah,
You can't go to 2-1, that's as far, because
Right.
that's only 3, because even a person abstained, they were present, so that would be a no vote, so we can't go to that.
There were
So
5 commissioners in the meeting, and 2 of them chose to vote no, and 3 chose to vote yes. That is then passed on as a tentative finding.
well, that is a direction to staff to prepare tentative findings.
Right.
Consistent with that 3. Then, what happens? Well, okay, so now at the next meeting, they come back. If if we have a change of the, you know, the two who weren't there show up, and say the two of, or at least one of the two, well, it was the 3-vote majority, so if one or two of the 3 voters aren't there, then we get into trouble, because who's eligible to vote?
And that's exactly my situation. So imagine that you have 3 affirmative votes the first time and 2 dissenting votes. It comes to the next hearing, 2 of the affirmative votes don't show up. So you now have 1 affirmative and 1 negative, but you then have 3 additional commissioners that are present as part of the quorum for meeting number 2. Could one of those people who did not participate in meeting number 1 declare that he felt, or the individual felt, sufficiently informed and would like to vote affirmative on the motion?
Yes.
You did that with me a year ago.
Yes, the answer to that is yes. In that case, you had the 1 affirmative, the 1 negative who were actually at the meeting and carried over. That'd be a 1-1 tie, you know, so what might have to happen if the others didn't review the record, that would have to continue over, because that's not a decision, okay?
This is exactly the situation that happened, and what you did was had me affirm that I had watched the tape.
Right.
You had me affirm that I had, not had ex parte, undisclosed, didn't have any biases, and at that point, I was allowed to vote, which gave a quorum or a majority of the votes necessary to move that forward.
Right. So that's the case, yes, a commissioner can review the record and then is entitled to vote.
Yeah.
Okay, once you review the record. Now, doesn't happen very often, but, you know, if all the commissioners did that, you know, at the next meeting, you might end up with the 3 who voted yes are now in the minority.
Right.
Because the other 3 who came in said, well, I reviewed the record and I disagree with you, and so now we have to have different findings.
Yeah. Well, I was relatively new at the time this happened, and you clearly did want my vote because it allowed that action to be moved forward rather than, you know, not moving forward or being denied.
Right.
And I was never quite sure why, what made that permissible. And
Because you had reviewed the record.
It was the fact of affirming that you had reviewed all of the record and didn't have the disqualifying biases or whatever. So that will make a previously absent commissioner eligible to vote on a finding.
Right, yes. And that, I mean, I think.
It's very rare, right.
Right, and that's also happened in cases in which we've had a continuation of a hearing where the commissioner missed the initial evidentiary hearing.
Right.
The matter was continued either for oral and written or just for written, and the commissioner says, I've reviewed all the record, so now I'm going to participate in the deliberation.
Yeah.
So that's certainly fine.
Yeah. Thank you very much, Evan. That was.
So, Evan, you might want to explain the time frame that you're operating under to the commissioners on why it's important to move things along within the 120 days, I guess.
I'll let, Jessica's the one who has to deal with the 120. I just have to go to court if she screws it up.
Well, I can't cite the ORS, but we are required to issue a decision 120 days from the day, starting from the day we call the application complete. And that means, that includes all potential appeals. So for instance, if it was a staff level decision that was then appealed to the DRC, which then could be further appealed to the city council, we need to get our staff decision out as soon as possible to make sure that we leave enough time for that to happen, because we have mandatory time periods in which we have to provide notice. So before a DRC hearing, we have to provide 20 days notice. Before a city council appeal, we have to provide 14 days notice. So it can be a juggling act. For most applications, it's not a problem, but for controversial ones, we can really kind of get up to the wire. We've had situations in the past where we've had to even schedule special DRC meetings in order to consider findings in time to meet the 120 days. Fortunately, that doesn't happen very often, but it does come up occasionally.
the worst case, the worst case that could be is, well, there's the notice that's going to eat up time. We can't shorten the number of days for the notices. We have 2 weeks between commission meetings. Sometimes we have 3, okay, if it's in. Then we have the council meeting, and we have 2 weeks for their adoption of findings, after their hearing. So just on the noticing and the time between meetings, that eats up, probably 9 weeks, of your 120 days. So usually there's like one, when the request for continuance is made, you're really pushing it right to the 120. It comes down to, like I think in the school district's case, even here, we project the council will hear this and would adopt findings, I think on April 4, don't quote me on that, and the 120 expires on April 5. So
tell them what happens if you don't make the 120.
what happens if we don't make the 120 is the applicant has the right, not the obligation, but the right to go to ask to file it in circuit court, to have the circuit court judge review the decision. So then it takes it out of the city, Parties don't like that, city council doesn't like that, we want to make our own local decisions, but then the circuit court judge, who, by the way, probably majored in criminal law, okay, that's how they get their appointment, is hearing a land use case about, this 2-foot variance, type thing. So they're upset. I'm sorry, that's editorializing. They're going to hear the case, and they will, it gets re-argued. Typically, it's more lawyered on both sides, so it's not as friendly to interested parties who are not represented by counsel. There's more expense, type thing. And both, believe it or not, this DRC and the city council are more knowledgeable about our code than the judge is. So trying to explain to the judge what the history of the decisions has been, the interpretation history and that sort of thing, is more difficult. So anyway, the judge ends up making the decision, which is not what legislature wants, not what we want. Plus, they get back, I think, half of their deposit. The applicant gets back, I think, half of their filing fee. So there's a financial reward to them to take it into circuit court that way too. And I can't recall if they get their attorney's fees or not. There is some monetary risk to the city.
Why don't we proceed to talk about ex parte contacts?
Me to cover that?
Yeah, if you could set that up.
Well, as I mentioned before, if we can come up with a guide, we can discuss ex parte contacts in there. But in general, I think the commission knows that, we've already touched on it, that you need to avoid ex parte contacts. But when someone specifically invites the commission, which this did happen at the last hearing, I invite the whole commission to come and, tour our neighborhood and I'll show you all the issues that we're dealing with. Well, obviously you can't do that. That's ex parte contact, plus having you all there would be a quorum, and there's problems with that. So, that's something that we could explain in a handout so that we can point to that. But I think the answer when someone invites you is, unfortunately, the commission can't make a contact or can't make a site visit because that is ex parte contact. If you want more information about ex parte contact, we have a handout, or you can talk to staff or something like that.
But couldn't they hear us in a later hearing say, oh yeah, I made a site visit? So I'm just saying, we said earlier, you can make a site visit if it's of our own doing, but it seems a little odd to then say to somebody, no, sorry, I can't make a site visit.
Right, and I think that's the,
If they're raising that at the meeting, at the initial evidentiary hearing, it's totally up to the commission to adjourn the meeting, to go make a site visit. Well, that's going to, we're 2 weeks further down the road. We're running out of time. on the 120, so that's a problem with that. And again, what's the evidence you want me to see? I mean, you came to the meeting thinking you had the context all in mind, type of thing, so it would take, I think no, I don't have the context in mind, and convince your other 6 commissioners. It's a hard bar.
Does the prohibition on ex parte contacts extend beyond the final adoptions of findings, conclusions, and order? For example, if an item is appealed to the city council, are we admonished to avoid ex parte contacts during the appeal period? And when does that end? Through LUBA or through?
Yeah. I guess technically there is a chance, because it has happened more than once. It has, that a case goes up to the city council and gets remanded back. Okay? So until, I think really until it gets out of the city council, there's still a chance it could go from city council to LUBA remands back to city council, comes back to the DRC. The requirement is you disclose ex parte contacts while the application is active, and it's going to be active until it's dead, okay? Until the LUBA has made its final decision and the time for appeal in the Court of Appeals is gone, what I mean, type of thing, technically. I would assume what you're going to get is people would contact you after the meeting to say, I was disappointed with your decision. Okay, they're not really to give you new evidence, because you're not the evidence decider now. So, and I think you can, when I've met with new commissioners, I've said you can also use that to say, look, you need to make your argument, before the DRC. After the meeting, there's nothing I can do, and there's no reason, I don't need to hear, from an ex parte point of view, I don't need to think, well, geez, in 4 months, when this comes back to me, what did you say to me, kind of thing. So, no, it's kind of, case has a beginning, a middle, and an end. From the DRC members' point of view, we're at, at the end until it gets reopened to us, so I'll talk to somebody else.
Would it be in order that maybe is on the back of the minutes or at the bottom, you could write that LU 220052 was approved by City Council on such and such a date, so we know. I mean, I never know if they get approved or not.
Or whether appealed, right? And then,
Yeah.
Well, I try to give you a council update, or in the management update at a meeting after it, I try to keep you guys up to date on what happened at the council.
Maybe I'm numb by then.
but
I may forget occasionally, but
Yeah.
I do
No, I
try to
just
do
meant-
that, yeah.
I mean, it doesn't have to be official business, but I mean, we could just list it that these have been approved or whatever.
I think the default is after the next meeting that it has not been appealed to council. If it is appealed, Jessica would let you know it's been appealed to
All right.
council. Then you're waiting to know, well, when has the council
Very
gotten
good.
done with?
Never mind.
I should be providing that in my management update.
I think
but
that
if
would be good feedback. I mean, just by happenstance, occasionally I will watch a city council meeting and I'll see that they're handling an appeal maybe once or twice. Has happened this year, or 2022. So I can kind of get that feedback. And I'm sometimes interested in what the various councilors are saying about the application that we discussed and deliberated and decided upon. But I think that feedback would be helpful, or just interesting for us as volunteers.
Yeah.
Who defends the appeal?
What's that?
If this is appealed to city council, who defends the applicant's position?
So the city council, applicant's position.
Well, if there's an appeal on this particular action we took this evening, who supports the decision made by the commission?
So what the staff will do is the staff will present the commission's
So
findings.
it is the staff broadly defined, might be both of you, might be the city engineer, might be whomever.
Yeah, it'll be the same staff project planner. So Evan Franstead was the planner on the bus barn application. So when that is appealed, he will present the findings that you just approved and the reasoning behind the decision. And generally what will happen is, the applicant or the appellant is required to identify the issues that they feel that DRC erred. And so we will write a staff report and refer back to the decisions and the findings of the commission as to why they made that decision and, you know.
Well, that clearly was what I assumed that was how this was done, which is why, frankly, I amended the motion to put in an explicit statement from the commission that we had reviewed this new material and could not find any justification. I mean, the new material, at least I think a few of us found that the new material was not in contradiction to the AASHTO code. And they also didn't present a statement that the site distance that was being proposed didn't meet anybody's criterion. So I wanted to get the commission to state that so that you would have that if this issue came back up at a city council. And that's a process that worked from your point of view, right?
Yeah.
Yeah.
Yeah,
Okay.
I think that'll be helpful to the council too,
Yeah,
because
yeah.
that issue will likely be raised, so.
Shall we proceed to an overview of the application process and steps
Absolutely.
before the application reaches the DRC?
Yeah, and I'm happy to talk about this because I think the orientation, we do talk about what happens behind the scenes. There's a lot that happens before an application gets to the commission. And so I'm going to cover both land use applications and tree removal applications because obviously they have a little bit different processes. As far as land use applications go, the first step is a pre-application meeting with staff. And it is required for almost every land use application that anyone files. They have to have a pre-application meeting with staff. There's a few exceptions, which I won't go into, but that pre-application meeting is a time for staff to give an overview of the process, all of the applicable criteria, and the fees that are involved. Neighborhood association reps of the neighborhood of where the site is located, they're allowed to send up to 2 representatives. So it's also an early opportunity for those, the neighborhood to hear about the project and provide some initial feedback, which is pretty unique. There aren't other cities that allow neighborhood reps to attend, I think. Well, it's not a public notice, but we send a notice to the neighborhood association and give them an opportunity to attend. They don't always attend, but if they're interested, they will. And they have to go through a pre-app training before they can attend on behalf of their neighborhood, just so we make sure, because it's not a public hearing and we don't want it to turn into a public hearing. It's just it's an informational session for an applicant, because sometimes they don't even ever turn into applications. It's also a time for us to discuss any prospective issues that we identified, like with traffic or parking or trees or sensitive lands, or talk about design, those types of things, and try to hash out those issues early on. It's also a time for us to tell them if we don't think the application could comply with the criteria for whatever reason. So in that case, it's a way for us to kind of say, you know, if you move forward, I don't think staff would be able to support this for this, and this reason. And so for that reason, they may never file an application. And that's why you don't often get recommendations for denial, because we've done our job at the front, because we don't want people spending, you know, investing time and money and effort into something that is not going to meet criteria. But also the perception from the public is we just approve everything. Well, it's because we're doing our job up front and making sure that whatever comes before you is something that can potentially meet the criteria. After the pre-application meeting, there may be a neighborhood meeting that is required. It's always required for any land division that includes partitions or subdivisions. They're always required for conditional use applications. We also typically require them for all new commercial, industrial, multifamily, or institutional projects. For things like minor variances or even major variances, those don't require a neighborhood meeting, but staff always has the discretion to require a neighborhood meeting if we feel that it would be beneficial. That might happen because we know the application is going to be controversial. We already know we have there's a lot of opposition out there. In that case, we want them to meet with the neighborhood, try to identify those issues and address them before they come up to the DRC. That's the purpose of the neighborhood meeting, is to, you know, try to work those out as much as they can before they come before you. Then the next step is that they'll submit the application to the city. At that time, we as a courtesy will just let the neighborhood association know that we received the application. And that way, if they want to look at it, it hasn't been determined to be complete, they can get in early in the process. And then the staff reviews it for completeness. We have up to 30 days. Once it's called complete, we send a letter to the applicant and we copy the neighborhood association and all abutting neighborhood associations. So then they know when the application's been called complete. If it's a staff level decision, then there will be a notice of application that will go out and there'll be a 14-day comment period. If it's a DRC application, then they get 20 days notice before the hearing. Then, oh, and it goes out to all properties within 300 feet. I missed that. The neighborhood association and all abutting neighborhood associations. So lots of opportunity to comment, lots of opportunity for neighborhoods to know what's going on and to organize and even personally get in touch with the applicant and discuss the issues even if a neighborhood meeting hasn't occurred.
And as you said, project is deemed complete, that starts the 120 days.
Correct. Yeah. And then it comes to the DRC and you know what happens after that. But so that's the land use process. For type 2 tree removal applications, once an application is submitted, we have staff who looks at it. There is no technical completeness review like a land use for a type 2 application. So somebody could submit to us and it could be missing a bunch of information. And we're obliged to take it. We can't reject the application like we could with a land use if it wasn't complete. But we work with the applicant. So if they submitted something and really they needed an arborist report or they needed to provide some more evidence and we could tell that they're missing a lot of information, we let them know up front and we don't accept the application until we kind of get them to a point where they're complete. So we have staff that's good about making sure that they've got all their information. Once we do, we post that application online so it is available for the public. We email the neighborhood association a copy of the application and that starts a 14-day comment period. During that comment period, typically the city's contract arborist will do the site visit and make the preliminary findings during that site visit for the type 2 application. At that time, she may find, well, you know, they said that this was damaging their house, but she goes out there and she can't see that it's damaging the house. And so she's going to say, I don't think they meet those criteria. So we'll go back to them and we'll say, hey, we don't have that evidence. Do you have any other evidence that you want to submit? Do you want to submit a evidence from a structural engineer? Do you have photos of inside the house that we can't see that documents the damage? Or we may say, you said the tree was in poor condition. We got out there in the site visit and it's not. And they may want to submit an arborist report. If they want to submit additional materials, we will actually then renotice the application because that's substantial evidence. We'll renotice the application, we'll resend it to the neighborhood association, and we restart the 14-day comment period. So we don't just automatically deny it. We try to help people along. Otherwise, we'd have a lot of mad people because people don't often take these applications very seriously. If the staff decision is going to be for denial or partial denial of an application, we always give the applicant two options. They can either, one, withdraw the application or withdraw the trees that would be denied, so partial withdraw, and we actually offer a partial refund. Or if they don't want to do that, then we would tell them we'll deny the application, there's no refund available, and then they would have the option of appealing that to the Development Review Commission. So we always provide that option. So there's a lot of applications that you never see because they've withdrawn or partially withdrawn the trees that we would otherwise have denied. And then if, something to note, if a type 2 application is associated with development that requires a building permit, we will not actually post the decision until we have confirmed that the proposed development actually meets the zoning code requirements. And until we do that, we put the application status on hold online. So if somebody looks at it, it says it's on hold. Once it's been confirmed that yes, it does comply, then we will move forward and issue the decision on that application. And that just makes sure that we're not approving something where they have to shift it because they don't meet a setback or they don't meet height or they have to significantly alter their plans. And then finally, when we do make the decision, it is, the staff decision is a tentative decision. And I know there's been some confusion on this. And the tentative decision is sent out with staff findings. It goes to the applicant, it goes to the neighborhood association, it goes to every single person that submitted a comment on the application. Those are the only people that have standing to appeal. And that will start a 15-day, what we call appeal period. Technically, it's a period to request a hearing because that decision is not final. If no request for hearing is filed, the decision becomes final, and that is the decision. If a request for hearing is filed, then it goes to the DRC. We call it an appeal. It's not technically an appeal. It's a request for hearing, but that's kind of how everybody thinks of it, and that's...
Yeah, the nomenclature gets confusing.
Yeah, it does, but that's how most people view it.
Question. So if I didn't ask a question, but I walk by and see a ribbon on a tree, I can't appeal?
If you did not submit a comment during the comment period, you do not have standing to appeal that to the DRC.
Okay.
However, once it's appealed to the DRC, anyone can come to that hearing and testify.
Okay.
Including that person that didn't initially
But
submit
if they
comments.
didn't, if somebody didn't actually write in and ask a question, then they can't appeal.
Correct.
So if nobody wrote in, I couldn't appeal.
The only people who could appeal at that point, if we receive no comments, is the applicant or the neighborhood association. The neighborhood association always has the opportunity to appeal. But only the neighborhood association in which the site is located in, not an outside neighborhood association. That's all I have, unless you have further questions on that.
What was your last point on neighborhood associations?
That neighborhood associations in which the site is located, they have standing to appeal even if they didn't submit a comment.
Okay. Any questions on that overview of the application process?
No, that was very helpful, though. Thank you.
Yep.
Thank you. Our next point relates to diversity of DRC members, and I think we have diversity of professional backgrounds, geographical diversity within the city, and perhaps philosophical and political diversity, as well as ethnic and religious diversity. So how can we perpetuate this and expand it?
I am not involved directly in the recruitment of DRC members. That is handled under the city manager's office. And if, for some of you who've been on the commission a while, you might remember in the old days, we used to do boards and commissions recruitment for all the various commissions as vacancies came up. And it was really hard to recruit members. So sometimes the DRC may have a recruitment in November, the Planning Commission might have a recruitment in July. It was all over the board. A few years back, they moved all of the recruitment of all boards and commissions to the end of the fiscal year. So I think they start in about May, make their selections, and then the new commissioners for the various boards and commissions start in July. And that's been a much better process because it allows people to apply for multiple commissions at one time, and so kind of increases the pool, et cetera. So that alone has been very helpful in having a larger pool of folks. But on top of that, the city also has a Diversity, Equity, and Inclusion Advisory Board, which the staff person on that, her name is Gillian Del Rio. She's wonderful. And I posed this question to her because I know that the DEI board has made recommendations to the city manager's office in order to help diversify the applicant pool. And she said that one of the recommendations that they recently implemented, or in this last round, was trying to expand the marketing and recruiting methods to outside of Lake Oswego. Because what they found is that while there is diversity within Lake Oswego, a lot of these groups tend to seek community also outside of Lake Oswego, and that could be with, let me see, she said it could be faith-based organizations, cultural organizations, different sports complex, parks, cultural centers, even grocery stores. And they also advertised in Washington, Multnomah, and Clackamas County, in addition to the traditional advertising methods, which included, just newspaper ads, social media, flyers, that type of thing. She said that she wasn't aware of any targeted recruitment efforts, particularly to increase women serving on the board, because I think if you've been on this board for a while, you'll notice that we haven't had a woman in a while. In fact, I've been here since 2001. I can only recall 2 women ever being on the board. So it's been hard to get women on this board, and I don't know why, because we've been successful in the Planning Commission and other boards. But I did let Gillian know about that, and she said that they could have a discussion about that in their DEI group to see if there's ways that they could try to recruit women. But one of the things that she suggested is, she said that one of the best ways, the most effective ways to recruit is word of mouth, because people are more likely to apply if it's recommended by someone they know. So for your friends and your colleagues and your acquaintances, if you have anyone in mind who you think would be good for any of our commissions, including the DRC, please do spread that word. That really helps us out, because I think that's probably one of the more effective ways. But that's what I have to report from Gillian, and I think she was glad to receive the feedback about trying to recruit more women to the DRC. So hopefully they'll look into that.
So is that the diversity that we're looking for the DRC, women or?
No, not just women. I mean, diversity, as the chair said, from all backgrounds, ethnicities, sex, political views. I mean, I think all of that is important. And also professions. So, I know we have a number of attorneys, but, it'd be good to have, someone from the development community. It's nice to have an architect. For a while, it was really hard for us to get an architect or designer on the board, but I think that's important too, or someone with an engineering background, or I know you do safety. Is that, I'm sorry. So, it's good to have a diversity of professions as well.
You mentioned advertising in other cities, areas. Is there not a residency requirement?
There is, but you can have a certain number, and I don't remember what it is, but you can have a certain number that
I
are
think it's
outside.
up to 2, can be in the urban service boundary. So it isn't, they can't come from Hillsborough, but the urban service boundary, and that does include the 3 counties area. So.
Is that be a residence or operate a business or own property, or you have to be a resident of the urban services boundary city limits?
I'd have to fire up my
Just out of
computer again.
curiosity, yeah.
Yeah. And it used to be, it was strict, like it had to have a certain number of profession, like it had to be from the architecture, real estate, and whatnot. They had to relax that because they just couldn't meet those quotas. But it does still say in there that there's a preference for those fields if we can recruit it. So, and Gillian, I do want to let you know, she did offer to come and talk to the commission if you wanted to, if you wanted more information about this. She'd be willing to come talk to. So I told her I would let you know that.
Thank you. Well, I appreciate that overview. Commissioners, it's getting rather late in the evening, and our next item was an update on past DRC recommendations, past and present. Do we want to review that tonight, or is that something that would be appropriate to table for the management update, perhaps at another meeting? Or do you want to proceed?
That sounds good, tabling for the management. I'd vote for that.
I think that might be appropriate. I appreciate your participation in this work session, staying until about 9:15 in the evening. Why don't we, unless staff feels there's an urgency about reviewing this?
No, I don't. I want to remind you that I did distribute the memo with a recommendation to the city engineer, if you wanted to take that.
Yes, and she was here earlier, and I regretted not asking her for her comments when we started our work session, and we didn't get to a breaking place, and so I see that she left, so I was sorry to keep her and not address that when she was here.
No, I don't think she was going to stay for that item
No,
anyway.
well, she was
so I-
here into our work session. I thought perhaps it was.
Mr.
Is there
Chair,
other
before you
men-
close, I can answer the question. You have to have 4 members who shall be, 4 members who shall reside within the city limits. Doesn't talk about the urban service boundary, so I guess you can have 3 from wherever. But it's residents, at least 4.
Jessica, what's our schedule anticipated for the next couple of months?
Yeah. We have a hearing coming up in the second, I think it's February 22nd. It's a Wednesday, so just be aware, because President's Day falls on the Monday, that we're meeting on a Wednesday. We have 2 items scheduled for that hearing. We have a possibility of 1 item scheduled for the first meeting in March, and that's all I have on the schedule so far.
Is there any other business this evening?
Other than the memo, no.
Did you want to discuss the memo tonight?
Yeah, so I distributed to the commission a copy of the memo. This was the motion that Commissioner Sangri brought up after the conclusion of the bus barn hearing that was passed by the commission. And it was for a recommendation to the city engineer regarding parking in the vicinity of 65th and Lakeview, prioritizing pedestrian improvements in that area, and also looking at coordination with Clackamas County on the improvements on Lower Boones Ferry Road between Southwest 65th and 63rd Avenue that had been recommended by ODOT. So I prepared that draft memo, which I know that, thank you for the chair and vice chair for reviewing that for your consideration. And if you approve it, then I can forward it on to the city engineer.
This was something that was included, I think, in our packets. And have we all had a chance to look at it? Are there comments about revisions to the memo, or is there a motion to approve it?
I'll move to approve.
Second.
Any discussion? So we,
I guess the little discussion that I had was that it struck me at the school, for the school issues, that, and I don't know if, it sounded like to me that the traffic, the city engineer decides where parking in there, and from the memo, the engineer decides where parking is and where, the parking issue, I guess. It's late, I'm sorry, it's been a long day. And it struck me, I think that, from my perception, the neighbors probably were talking to the wrong body about the fact that there was no parking. That a lot of the problems I thought could have been solved by saying you can't park semis on the street so that, but it's like, we're the DRC, we can't do that. And so do the citizens go to the city engineer, or do they go to the council members and, you know, bang on the table saying, things gotta change, we don't have more, you know, semis parked in my neighborhood, because then the little school buses run over the kids, right? So, I mean, is that the theory at least, or?
Well, I think they could do either. I mean, it is under the purview of the city engineer, and certainly if they were receiving a lot of complaints or got formal complaints from the neighborhood association, which happens with some neighborhood associations where they're very organized, and then the city engineer can look into that. Or if someone testified at council, then the council may look to the city engineer and say, hey, can you look into this? So I think either mechanism would work. Yeah.
Vehicles were in fact parked in no parking zones. It was, you know, that's why I put the comment to review
About
parking and
enforcement.
enforce parking.
Right.
Because if they enforced the parking, they would have eliminated some of the examples that we saw of bad parking.
Yeah, and that's police department, and certainly if
So it's really everybody.
made them aware of that, they could increase enforcement in that area if that was a priority.
so we have a motion and a second, I believe, to approve the memo. If there's no further discussion, we can take a vote.
Arthur?
Yes.
Smith?
Yes.
Shear?
Yes.
Poinsett?
Yes.
Bangry,
Yes.
Lyons,
Yes.
Doze,
Yes.
0.
Very good. The memo is approved to go to the city engineer. If there's no other business, we will adjourn the meeting, and Commissioner Shearer and I will let you know when we have the next city council viewing party. Thank you. The meeting's adjourned.